Sure.
Okay. So please proceed.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Good afternoon to you, madam, and all of my friends. So today, Ayurus and Associate will present to you the case of Murfang Keluar Maritime, Yunus Berhad, and Philip Kotongi. Okay, without further ado, we start our presentations.
Assalamualaikum warahmatullahi wabarakatuh. My name is Rawatusna. I will present on the facts of this case. Okay, in this case, the defendants owed the plaintiff a duty of care to exercise professional skill, care and diligence, which is demanded by law, in advising all legal aspect regarding to the transaction in handling the sale and purchase of two plots of land. And um, the plaintiff discovered that after the payment of the full purchase of the two plots of land to the vendors, a certain amount of that land, of the land area for the two lots had been surrendered by the vendor to the state authority, which is known as surrendered area. Okay. And the plaintiff tendered that one of the conditions in the SNPs is the plaintiff rely on the defendant's assurance and advice. Therefore, the plaintiff claimed that the defendant is obliged to advise and exercise professional skill against the defendant of the land area which had been surrendered by the vendor to the state authority. And however, um, However, the defendant failed to do so in protecting the rights and the interests of the plaintiff. And the defendants contended that the plaintiff was contributory negligent as the plaintiff has its own internal legal advisor who had extensive experience on commercial development that had ability on detecting the surrender area.
Okay, next we moving on to the issues of the case. First issue, whether the defendant owes a duty of care as conveyancing solicitor to the plaintiff in handling the sale and purchase agreement of the two lots. So in this first issue, it will discussing whether the advocate and solicitor should advise on the circumstances specifically stated under a retainer or beyond the retainer. It will also discussing whether the defendant has a duty of care to advise plaintiff regarding the surrendered land before the release of balance purchase price. So for the second issue, whether the defendant has breached their duty as conveyancing solicitor and were liable to the negligence. So in this case, in the second issue, we will discuss whether the defendant liable for any loss and damage suffered by the plaintiff. As in this case, the plaintiff suffered loss when he received lesser than what was purchased, and he did not get what he wanted as in the contract. Next, we move to the judgment.
All right, thank you, Norisha and Husna. So now I proceed with the judgment of the case. Okay, for the judgment, based on the two issue, I quote what have been Norisha said just now. For the first issue, whether the defendant or duty of care in handling the sale purchase agreement that was entered by the plaintiff. Here, the court looked at the case of the Macedo and Pabri, where it was quote in this case, it is duty of solicitor to warn the client in any circumstances that may affect the transaction that have been made by his client. And also, in this case, the judge also quote the case of Hawking and Clayton, where it was deliberated here, the lawyer owes duty of care to his client, where the lawyer need to take any reasonable step to prevent his client to suffer any loss. So based on this principle and based on the fact that was given by the Husna just now, the court have given a great judgment where it was agreed that the defendant ought duty of care to advise his client on the implication if the client entered the sale and purchase agreement on the two lots that was disputed in these cases. And also it was agreed by the court where the defendant need to advise beyond not only on mere documentation, but must be beyond the documentation, and everything, all the information must be advised detail by detail A to Z. Okay, I move to the second issue, whether the defendant have breached the duty. Okay, right now the court look at the case of the Mercer Young and Co. and Wing Hot Tech Development, whereas it was quoted in these cases, the solicitor have a contract duty to consult his client. And also here, the court look at the case of Laifor and Son, Senior Barahat and Scrime, where it was also deliberated here, it was prudent for solicitor to protect their client interest. So based on this principle and other principle that has stated in this case and our current fact, it was agreed, and again the court have gave a great judgment where the defendant had failed to protect his client interest, and also the defendant had also failed to provide the professional advice that need by his client. So based on this judgment, the court have given out the order. But for the first one, it was ordered to the defendant to pay his client, the plaintiff, more than 3 million ringgits with the interest 5% per annum. And also, the defendant need to cover the cost by the plaintiff to the court amounted to 20,000 ringgit. So that's all for the judgment. Thank you. We proceed to the next presenter.
Yes, Assalamualaikum, madam. Okay, now we move on to the commentary and analysis. Okay, now in this case, what we'd like to comment here is, first of and foremost, it is well established that a solicitor owes a duty of care to his client, and he must certainly conform to the standard of care required by the law profession itself. And first and foremost, we'd like to highlight, as a convincing lawyer, it encompasses two duties. First of all, a specific duty of the solicitor under the retainer, and secondly, the duties of the lawyer under tort or general responsibility. Thus, a solicitor, generally, he owes a duty of care to his client. And not only on matters, he is also expected to practice due diligence and also reasonable skills in executing his work towards his client. A solicitor not only is bound, madam, to advise his client on matters which is specifically requested by his client, but also on matters which may affect his client's benefit or which may affect his client's interest in the contract. So even though his client may not ask the specific question or may not request it in the retainer, but the solicitor, as since he is the solicitor for the client, he ought to exercise the respective due diligence and also advise his client on matters which may have an effect or which may impact the client's benefit in the contract. And moving on, if you look at this case, where we say the solicitor must always act in the best interest of his client, here during the land search, and initially during the land search, the lawyer was very much aware that there were two lots of land and there were surrendered areas that were given to the state authority. He was aware of that, but when he gave the result of the land search to his client, he did not advise them about it. And his argument was quite unprofessional. He said that since the client, which is the defendant here, is a large corporation and which consists of legal advisors, they ought to have more knowledge about it. So we find that we are of the opinion that this is quite a lackadaisical exercise from the lawyer. But if his argument is that the defendant itself is a large corporation, a large company, they must know about the surrender area, then there's no point in appointing him as the lawyer in the first place. So we find that his attitude and his professionalism is very unprofessional. And the court also highlighted the fact that he is a 15 years experienced convincing lawyer. And as a 15 years experienced convincing lawyer, the reasonable skills and also due diligence expected of him is very high due to his experience. And also he did not act in the best interest of his client when he did not prevent the balance of purchase price before releasing it to the vendor, even though he have knowledge regarding the surrender area, which will not benefit the contract entered into by his client, but he still released the balance purchase price to the vendor. And from that, we can conclude that from this case that it is very pertinent that for a lawyer to owe a duty of care to his client, not only on matters that is conform to the law, but also must act in the best interest of his client in the circumstances of the case, and ensure that the client will get the full fruit or the full benefit from the contract that has been entered into. That's all from us, madam. Thank you.
All right, madam, that's all from us.
Okay.
Thank you.
Thank you very much, Group 1, on the presentation of Mufa Keluang Maritime, Mufa Keluang Maritime Carrier Sdn Bhd. On the gross negligence committed by the lawyer is actually the failure to advise the client on the status of the land, whereby part of it have been surrendered to the state authority. Okay, so from this case, we can see that it is very important for the conveyancing lawyer actually to carefully scrutinize the land search result. It is not just a standard land search and you just file it in your file, but you have to look at the details of the land search in order to know if there is something happened to the land. It is very late for you to discover it at the very end of the stage whereby the payment already paid to the vendor in this case. And then if you notice, it cost the firm 3 million plus to pay for the damages to the client in this case because of their negligence. So thank you very much, Group 1, for Mufa Keluang Maritime Carrier Sdn Bhd. We can learn a lot from this case, from what we should do as a conveyancing lawyer and as a lawyer in general. Okay, so we are going to move on to the second group, which we will call upon the second group for the case of Wan Xiao and another, and Kok Wen Tak and others. Which one will be presenting this case?
Hakim Ng Associate. We'll share the slide first.
Okay.
Test. Bismillah. Assalamualaikum warahmatullahi wabarakatuh to my respected and beloved Madam Kamila. Today we are from Hakim Ng and Associate. We'd like to present on the case review entitled Wang Xiao another and Kok Weng Tang another. Okay, in this case, the plaintiff are Madam Wang Xiao and Mr. Lee Chun Leong, while the defendant are Kok Weng Tang, which is first defendant, Yap Sok Hong, second defendant, Sujata Pham Chess, third defendant, and the judge for this case is Suraya Osman from High Court Malaya of Shah Alam. The cause of action arose when the defendant had breached their duty of care as advocate and solicitor to act with reasonable care, skill and diligence to ensure that the property was free from any charge or encumbrances. Okay. According to Section 94, Subsection 3 of LPA 1976, professional misconduct is defined as a conduct or omission to act in a professional capacity which amount to grave impropriety. The laws regulating a lawyer and solicitor in Malaysia are divided into two sections. Firstly, the traditional written rules that include but are not limited to the LPA, Legal Profession Practice Ethic 1978, and Solicitor Accounts Rule 1990, and Bar Council Rule, as well as the unconventional rule that are unwritten common standard of decency and fairness.
The conduct and ethic of a lawyer and solicitor is governed by this law, and a portion of it require the responsibility to the customer. Section 94, Subsection 3 also provide a list of behavior which amount to misconduct, such as A. Being found guilty for a criminal offence. B. Breach of duty to court, including a failure to comply with promise in the course of legal proceeding to a court. C. Dishonest or fraudulent conduct. And D. Breach of any rule of practice ethic of professional. Then E. Being declared a bankrupt. So, the consequence of being found guilty for professional misconduct may include a fine not exceeding 50,000, reprimand, or censure suspension as per section 103C of the LPA 1976. Okay, we move on to the first case.
Okay, next for the facts of the case. Okay, firstly, in 22 November, the plaintiff purchase of a 3-story shop office from TI Logistics, Sdn Bhd. Then the plaintiff also had appointed the defendant to prepare a sale and purchase agreement concerning the purchase from the vendor. After that, pursuant to the sale and purchase agreement being executed, the plaintiff had completed to pay a deposit sum of RM120,000 to the vendor. After 4 months after that, after the execution of sale and purchase agreement, the defendant lodged a caveat on the property, but the caveat was rejected by the land office. However, the defendant were unaware of this rejection. Then, in 20 March 2013, the plaintiff discovered that the said property had been auctioned off by CIMB Bank Berhad to a third party due to the failure of the vendor to service the loan taken for the property. The plaintiff suffered a loss that because they already paid the deposit amount and the damages when a property was sold to a third party. Therefore, the plaintiff sued the defendant for professional negligence by breaching their duty to act with reasonable care, skill, and diligence. Okay, then the plaintiff also had conducted a search on the title of the said property, which is 3-story shop office, and revisited the SPA date 22 November 2012 and found that the defendant had breached their duty of care to the plaintiff. In this case, the plaintiff's main concern is the loss that they had suffered for the deposit amount paid and the measures when the property was sold to a third party. That's why the plaintiff sued the defendant for professional negligence for failure in taking reasonable steps to ensure that the property was free from any charge or any encumbrances. Okay, there are 3 issues, which are firstly, whether the defendants had breached their duty of care as solicitor in the matter of their actions in the sale and purchase agreement. Secondly, whether the plaintiff had suffered any loss or damages as a result of the defendant breach of duty of care as conveyancing solicitor. And thirdly, whether the plaintiff were entitled to claim the deposit sum with interest and cost. Okay, next we move on with a judgment by Faiz Hakim.
Thank you, narrate and our name. Okay, we proceed with the judge. Okay, first the court held that the defendant owed the existence of the relationship, which is the solicitor and client relationship, as the defendant firm was entrusted by the plaintiff for the sale and purchase agreement. Okay, and secondly, for the third defendant negligently misrepresented the plaintiff that the property was free from any game. That the property was free due to the misrepresentation by the defendant. Okay, thirdly, the third defendant failed to rectify the sale and purchase agreement. Once the third defendant notified that there was encumbrances on the property. Okay, four, the third defendant failed to take reasonable precaution against reasonable probabilities. Okay, the third defendant make a search and check properly against the property in issue. Okay, due to the professional negligence conducted by the defendants against the claim, but loss of the deposit sum amounting to 120,000 ringgit paid to the vendor as the property was cannot be used anymore, and it has become and it has been transferred to another parties. Okay, and then we will proceed with analysis by my learning friends. Thank you.
Okay, so for the analysis, this case points out the duty of care as solicitors in sale and purchase agreement, which is not only to provide and fill out forms that are needed by the statute, but also to practice necessary care towards the practicing of the agreement. In the case of Datuk Seri Aubachi and another against Malayan United Finance Berhad, the court stated that the relationship between the solicitor and client is contractual, and thus the solicitor has the duty to consult with his client when there occurs some doubt or encumbrances. The court also stated that the client shall be kept informed on a level of reasonably necessary according to some criteria. In the present case, since the firm has been retained by the plaintiff for the sale purchase agreement of the property, it is undeniable that there exists a client and solicitor's relationship between the parties, and thus the defendants owe the plaintiffs a contractual duty. In a federal court case of Mos Yong and Co. against We Hood Tech Development Corp. Limited, the court opined that at common law, a solicitor is obliged to be skillful and careful, and failure to act according to this condition will make him liable in contract for negligence, regardless whether he is getting paid for it or not. He also is liable for his wrongful act and may be held liable in tort if the circumstances fit the charge. In the current case, the defendants made a mistake by representing to the plaintiff in recital 2 that the said property was free from encumbrances when it was charged to CMB. In evidence by Mr. Lee Chun Leong, the second plaintiff, the defendant did not communicate neither the mistake to recital 2 nor the mistake of the said property being charged to CMB. However, despite knowing the relevant and actual fact, DW1 still drafted the SPA with wrong and misleading facts, stating that it was free from encumbrances. Also, by entering the wrong title deed particulars in the SPA, as well as representation that the property was not registered in the name of the vendor. Also, the plaintiff must show that there is an act that link between the loss they have suffered and the defendant's wrongs. In the case of Wu Siu Ying against Gunung Tunggal Quarry and Construction Sdn Bhd, the issue is whether the BAT4 test was applicable in a negligent action where there were overlapping factors causing harm to the plaintiff. In the present case, it is the plaintiff pleaded case that the loss of the plaintiff's deposit sum of 120,000 ringgit was caused by the defendant's breach of duty of care or negligent conduct in performing their duty. The defendants, on the other hand, contended that the cause of the loss is clearly due to the vendor's failure to service its bank loan with CIMB that caused the property to be auctioned off by CIMB. This then caused the SPA to fail, and thus the loss of the deposit of 120 ringgit 120,000 ringgit as claimed by the plaintiff. The defendant did not exercise due diligence, reasonable care and skill even before the property was auctioned off. Applying the but-for test to the part of this case, it was clear that the effective cause of what materially contributes to the plaintiff's loss was the acts or inactions of the defendant in not ensuring that the property was not subject to a charge. Even if the property was subject to a charge, the defendant failed to inform the defendant and to enter a private caveat on the property to safeguard the plaintiff's interest. So for the conclusion, general law in relationship between a solicitor and client gives rise to a contractual duty by the solicitor to exercise due care and necessary skill in carrying out his duty. A solicitor has to take necessary steps in ensuring the property is free from charge and encumbrances. He must also be aware and, more importantly, notify the client of any changes of circumstances of the property in the said SPA, as well as making sure that the details of the property are correctly and precisely stated. Otherwise, the client will be the one who suffer damages. This is well illustrated in this case that the main cause for loss suffered by the plaintiff was not the action of the property by CIMB due to the failure of the vendor's obligation to service its loan, but because of the defendant failed to exercise reasonable care and diligence even before the issue with CIMB arose. That's all from us. Thank you.
Okay, thank you very much, Group 2, on Wan Xiao and other and Kok Wen Tak and others. So what was the gross negligence committed by the lawyer in this case?
That he's unaware that the caveat has been rejected by the land office. So he's unaware of that the rejection.
Okay, there is one. He does not aware about the rejection, or but why the caveat was rejected actually? Why do you think the caveat was rejected?
Because the detail of the property are not correct and precisely stated.
That was in the sale and purchase agreement, kan?
Yes.
In this case, the problem is because the lawyer actually had mistakenly stated in their agreement that the property is free from encumbrances, whereby the property is actually not free from encumbrances because it is currently charged to CIMB Bank. And so I think that is why the caveat was rejected, because there is a pending action by CIMB to actually auction the property at that time. So it was rejected. So that's why the client later on suffered loss, because the property was auctioned off by the bank and by CIMB Bank, and they cannot proceed with the sale and purchase agreement. As a lawyer, in this case, what he actually supposed to do when he aware that there is an encumbrances over the land? Apa yang dia patut buat sebagai conveyancing lawyer?
Notify his client about the encumbrances.
Notify his client about the encumbrances, so the client aware that there is a charge, and as a lawyer, what he's supposed to do? Yes?
Madam, as a lawyer, he's supposed to apply for another caveat.
Nampak another
Uh,
caveat. Okay. So how do you actually inform CIMB Bank that the vendor is actually selling the property?
Giving notice, madam, to the CIMB Bank.
By giving a letter requesting for a redemption statement to state CIMB Bank. So you give a letter informing CIMB Bank that there is one person who actually would like to buy your property, this property, and this person is actually redeeming the property from CIMB Bank. Kalau kita buat file yang individual file tu pun kita ada, kalau property incumbent, we will request for redemption statement from the bank to know how much money owed by the vendor with regards to the property. Yeah. So in this case, it unfortunate that the lawyer actually failed to state in the SMP that the property is currently there is encumbrances, and in fact the details in the SMP also is incorrect. So this is something that very glaring mistake by the lawyer. Okay, thank you very much, group 2. So we are going to move on to the last group in TLB 7, which will present the last case, Kok Wenta and others, and Mbang Berhan. Which firm will be presenting this case? Azia, your group will be presenting this case?
Yes, madam. Hana and
Yeah.
will be presenting this case.
Okay, so your team member?
Nur Azia,
Okay.
Siti Nur Arifia, Najla,
Okay.
Najla and Hadri.
Hadri, okay. Say, okay. You may proceed now.
All right. Everyone can see the slide?
Yes.
Yes.
I will proceed with the facts of the case first. Okay, in this case, the developer had entered into a sale and purchase agreement with the purchaser, in which the purchaser had been offered with letter of offer from Ambang, in this case the plaintiff, to the purchaser for loan facility. The bank then appointed a solicitor, in this case the defendant, to act for the bank for verification security with regards to the loan given to the purchaser. The solicitor also guaranteed the bank that if they lost any suffer due to the negligence or in relation to the verification obtained from the solicitor, the bank will be indemnified. One day, the bank had received letter of advice from the solicitor stating that the fourth dependent is the sole proprietor of the property, and as the result, the bank had issued the check to the fourth dependent. However, the bank found that the developer did not recognize the fourth dependent as the assigner of the property. This means that the fourth dependent is not entitled for the check given by the M-Bank previously. This also means that the solicitor had failed to follow the mandate given by M-Bank. In other words, the solicitor did not do the verification work properly. Instead, they hired a freelance dispatch clerk to do the liaising with the developer, in which it should have been done by the solicitor in the first place. Now the bank contended that the law firm had breached their fiduciary duty to the bank and acted negligently pertaining to the legal documentation for the loan facility. Well, the court then allowed for the bank's claim but held that the bank is also liable for contribution of negligence, hence the appeal made by the bank. Next, for the issue of the case.
Okay. Um, so for the issue in this case, there are two issues. The first issue is whether the High Court judge was correct and he found that the law firm had committed negligence and breach of contract. Okay, and then the second issue is whether the High Court judge was correct when he found that negligent, because in the High Court judge had stated that the High Court allowed the plaintiff applications. However, the court stated that the bank itself contribute 30% for the negligence in verifications of the defendant liability, and 30% is for the bank itself that need to be contribute regarding the negligence. Yes. So now we're moving to the judgment.
For the judgment for the first issue, the law firm has breached its contractual obligation by failing to liaise directly with the developer in its verification duty as spelled out in the mandate given by the plaintiff. Instead, the third defendant or the solicitor of the firm had employed a freelance dispatch clerk to carry out the task. So it was referred to the case of WeHood Tech Development Corporation, whereby it stated that the liability of a solicitor may be viewed in two aspects. At common law, the retainer imposes upon him an obligation to be skillful and careful, and for failure to fulfill his obligation, he may be made liable in contract for negligence. And a solicitor is liable for his wrongful acts. And if the circumstances justify the charge, he may be made liable to his client in tort. And then the law firm also was liable for negligence as it had failed in the discharge of its duty of care to the plaintiff in ensuring that the information required by the plaintiff was obtained by liaising with the developer properly and truly. For the second issue, the learned trial judge was in error when he found that the plaintiff have contributed to the loss it had suffered. The court then varied the decision of the learned High Court judge, as it was found that the law firm was 100% liable for the losses suffered by the plaintiff, whereby through its negligence, the operation of clause 15 of the letter of advice from the law firm to release the loan facility had been triggered. It was recalled that the said clause 15 stipulated that the law firm had agreed to indemnify the plaintiff in full in the event, among others, that it was found to be negligent. The court relied on the case of Burnett and Chelsea, whereby the application for the but-for test was applied. Namely, would the result have occurred but for the act or omission of the defendant? If yes, the defendant is liable. So in short, the court dismissed the appeal by the law firm and had allowed the cross appeal by the plaintiff, and also had ordered the said law firm to pay cost of 30,000 ringgit to the plaintiff.
Hello? Hello? Okay, for the analysis or the commentary, the solicitors handling legal documentation for land transaction must be competent and well versed with the applicable laws and procedure. So, a conveyancing lawyer must...
Adri, boleh kuat sikit Adri?
Hello?
Okay, kuat sikit.
Okay. So a conveyancing lawyer must be an expert with
the applicable laws and procedure regarding the transaction of land. So the solicitors must ensure that proper verification exercise is conducted to identify the details of the property, any encumbrance, restriction in interest, and identity and legal capacity of the contracting parties. In the event that there is any loss suffered by the parties due to negligence on the part of the lawyers, the said lawyers may be held liable for breach of contract and professional negligence. Hence, it is advisable for owners of law firms to adopt the best convincing practice or implement proper monitoring to assist them in discharging their professional duty to the client. So if we see in this case, the lawyer had what we call go for a freelance dispatcher and without and to go to the developer, but after that he did not make any extra caution step to verify the information that has been brought to him. It is a duty for conveyancing lawyer to really be careful with the what do we call the procedures, so that there will be no mishap and the client's money will be secure. That's all from me.
So is it that's all from group 3?
Yes, madam.
Yes.
Okay. So thank you very much, group 3, on case Kok Wan Tak and Mbank. Kok Wan Tak and Mbank. So actually, who committed the fraud in this case?
The solicitor.
It's another fourth part. The
For defendant.
For defendant. For defendant.
Who is the fourth defendant?
Is a fraudster that claimed to be the developer.
Is it?
No, the fourth defendant is the one that claimed that he is the sole proprietor of the property, on which he is the one who deal to sell it to the purchaser.
He is the vendor. He claimed to be the vendor in the transaction, which is in actual fact he is not the true owner of the land. He is a fraudster, but claimed to be the vendor and sold the property to this purchaser, and this purchaser actually obtained a loan from Mbank. Then this lawyer actually advised Mbank to release the money to this fraudster as a vendor. Without noticing that there is a fraud in between, which is actually organized or by these fraudsters, which is the fourth defendant in this case. Okay, so we have learned from this case that even though it is very unfortunate for this firm actually, because it happened that the person that they deal with was a fraudster, and they can't notice it until the end of the transaction. But is it wrong for the firm to engage with a freelance dispatch club in this case? Is it wrong?
According to the lawyer himself, they said that it's not a normal custom. This is not a common act to hire a freelance dispatcher.
Okay.
And one thing is that in the mandate itself, the bank already asked the law firm to directly engage with the developer and not appointed anyone between them in the with this matter.
Okay. So actually, it is not wrong to engage a freelance clerk or freelance runner for a firm, but the only thing is that you must be extra cautious when they are not the full-time staff in your firm. Okay, so thank you very much, Group 3. So we have finished with the LB7 for the 3 presentation. Now we are going to move on to the LB8 for the first case. So which group will be presenting the first case? The LB8. Mofa Kluang case.
Sekejap, madam.
Can you see the slide? No.
Not yet, Nadia.
No.
If you face the problem, maybe you can attach the group in WhatsApp group and others can help.
Tak nampak lagi ke?
Belum muncul lagi. Okey tak, Nadia? Okay.
Sekejap madam, saya suruh kawan saya tolong tu.
Okay.
Okay, madam, can you see?
Okay. Okay, dah keluar dah.
Okay. Assalamualaikum warahmatullahi wabarakatuh. We are from Prisman & Co. Will be presenting on the case of Mulfa Kluang Maritime Carriers and Berhad against Philip Koh Tong Ni and others. Okay, for the first, I will give a brief introduction on this case. In this case, as when it comes to litigation involving professional negligence, the court will inspect all the process and steps taken by conveyancing lawyer from the first stage of verifying the material information pertaining to the sale transaction until final stage where the relevant agreement is signed by both parties. In sale and purchase agreement, either it involved with land purchase or property, an official search must be conducted to find out further about that land, or the previous transaction with those land can be found in the IDT. For conveyancing lawyer, it must exercise due care and skill required of a competent solicitor in ensuring the purchaser has obtained the vacant position. Pertaining to stakeholder, advocates and solicitor were to hold the balance purchase price as stakeholders and only release it to the vendor upon delivery of vacant position under the terms of sale and purchase agreement. Proceed to the fact of the case.
For the fact of the case, the plaintiff had asked for legal advice from the defendants whom he had retained as his lawyer for the sale and purchase of 2 lots of land. However, as he completes the payment for the purchase, the plaintiff found out that the vendor had surrendered a portion of the lots to the state authority in 1988. Its particulars had been endorsed in the issued document of title of the lots and the land search conduct by the defendant. Upon his suit against the vendor was dismissed, the plaintiff then filed this suit against the defendants based on the ground that the defendants, as his sale and purchase lawyer, had breached the contractual duty and had committed negligence on him.
Okay, there are 2 issues in this case, which is the first issue is whether the defendants owe a duty of care as a solicitor for the plaintiff in handling the sale and purchase transaction of the 2 lots. And the second issue is whether the defendants had breached the duty of care as a solicitor. As for the judgment of the first issue, the plaintiff had retained the defendant to advise and provide legal service in respect of the transaction of the 2 lots and to handle all conveyancing matters including the preparation, sale and purchase agreement, memorandum of transfer, land search and all other related documentation. It is the duty of a solicitor to ensure that all the documents pertaining to the transaction of land must be properly prepared, to carry out a thorough inquiry and to ensure that all the details which is stated in the transaction document is correct. Therefore, as a solicitor, the defendants owe the plaintiff a duty of care to exercise professional skill, care and diligence demanded by law in advising all legal aspects with regard to the transaction in handling the sale and purchase of the 2 lots. As for the second issue, the judgment is, even if there were no express instruction from the plaintiff for advice in regards to the surrendered portion of the lands in lots 643 and 644, the defendants had nonetheless breached the duty of care by virtue of failing to exercise the standard of care demanded by law. Therefore, the defendants had breached the duty of care for failing to advise and exercise requisite care and skill in regard to the surrendered area and thus liable for negligence. The plaintiff do not have a duty to instruct the defendant as to every step which needs to be taken for the sale and purchase agreement of lot 643 and 644. It is the duty of the defendants to inquire with the plaintiff and to advise the plaintiff in the standard of care demanded by law in all legal aspects with regard to the transaction of sale and purchase of the 2 lots.
For the purpose of hearing Madam Iqtal from for the comment and analysis, from our opinion, the judgment given by court is correct and the law that they use is on point. As a lawyer, it is our job to ensure all the documents relating to transaction of land to properly prepared, especially in terms of legal issue. It is important to make sure that the document and act of our clients do not break any rule. Advocate and solicitors are a professional job that exercise professional skills, so that when it comes to advising legal aspect professionally, it must do with care and diligence. As the court used the case of McIndo and Parbury, it is clear that it is a duty of an advocate and solicitor to warn the client anything that is unusual or anything that would affect the contract of the client get the full benefit of it. In the case of Muta, the client wants to buy land which is a surrounded area. The conveyancing solicitor have to ensure all the legal requirement to buy the land is fulfilled before advise it to do so. At the very least, they should ask about the status of the land, either it is available or not. There are the cases that can be used in this case, which is Anthony Teng Chiao Pang and Wong Bing Seng and another, which in this case, the court held that the solicitors were negligent in failing to properly ascertain the true identity of the person who claimed to be owner of the land, and it was held that the solicitors to be negligent. We also agree that all the elements breach of duty, which are the defendant owes duty of care, the defendant breach the duty of care, and plenty suffered loss, and the defendant conduct that the damage was fulfilled. And there is other case that can be used, which is Kong Wek Tak and M Bank. This case had discussed about the duty of care by the solicitor. In this case, the law firm had subsequently, without checking with the developer, acted on the information that had been given, which this act has result loss for the plaintiff. The court held that the law firm had failed in the discharge of its duty of care or to the plaintiff in ensuring that the information required by the plaintiff was obtained by liaising with the developer properly and truly. Therefore, the law firm was liable for negligence. And for the conclusion, we agree with the authorities and decision given by the court. Next presenter.
Okay, for conclusion, under the terms of sale and purchase agreement, advocate and solicitor are responsible to hold the balance purchase price as stakeholder. However, in this case, the solicitor failed to ensure that all two lots were obtained fully by the plaintiff. And the solicitor is liable for loss of the purchaser for releasing the remaining purchase price to the vendor where the purchaser did not obtain or receive the vacant position as stated under the SPA. The Bar Council in the Rule 14.10 Clause 3 also stated that a solicitor acting as stakeholder for two or more parties must strictly adhere to the term of stakeholding at all times. That's all. Thank you.
Okay, that's all from group 1.
Yes, madam.
Okay, so what was the defense given by the defendant in this case? Anyone from group 1? What was the defense put forward by the defendant, by the legal firm?
The defendant claims that it was contributory negligence as the plaintiff representative should appraise for the searches and the condition of the land.
Okay. Yang lain? Apa defense yang diberikan oleh pihak by the legal firm? Nadia?
The defendant argued that the plaintiff has his own professional lawyer, and he said that it is the responsible of the plaintiff's lawyer to ensure about the land, but it is actually his own responsible because he is the conveyancing solicitor for the plaintiff.
Okay, that is one of the argument given by the defendant, because they said that the company is a big company and they have in-house legal advisor, so they should also aware when they receive a copy of the land search from the defendant, from the legal firm. But of course, this argument is not valid because the purpose of the client engage the solicitor to do the transaction is because they have the expertise in handling the transaction. So they cannot push back the blame to the other party by saying that they have their own expertise, they are big company, a big conglomerate, they have their own legal advisors, so they should aware about that. So thank you very much, Group 1, for the presentation. Now we are going to move on to Group 2 on Wang Zhao and another, and Kok Wen Tak and others. Okay, which firm will be presenting this case?
Wafa. Mrs. Wafa.
Okay. Adila? Wafa and Associates, yeah? Okay. You may start now, Adila. Oh, who is going to
I
present?
will start first. My name is Wana Atira.
Okay.
So today I will give the overview of the case. The area of law involved in this case are tort negligence and in contract where the defendant failed to fulfill his duty of care as an advocate and solicitor to his client, and in breach of contract in a sale and purchase transaction. This case stresses on the obligation that an advocate and solicitor has to their client. An advocate and solicitor has to perform their duty with due diligence and the required skill and care. Next, we will move to the fact of the case.
Okay, we move to the fact of the case. In this case, the plaintiff is Madam Wang Xiao and Mr. Lee Chun Leong. For the defendants, there are three defendants, which is the first and the second defendants is the an advocates and solicitor and partners of Mercer David Kok and partners, while the third defendant is a legal assistant. This case happened on 22 November 2012, where the plaintiff had appointed the defendant to prepare a sale and purchase agreement to purchase a three-story shop office from TI Logistics Sdn Bhd, which is the vendor. Pursuant to the SPA being executed, the plaintiff had completed to pay a deposit sum of 120,000 ringgit to the vendor. And 4 months after the execution of the SPA, the defendants had lodged a caveat on the property, but the caveat was rejected by the land office due to the, as Madam said earlier, due to the encumbrances by the CIMB Bank. And the defendants, however, failed to aware of this rejection. So on 20 March 2013, the plaintiff discovered that the said property had been auctioned off by CIMB Bank Berhad, which is in this case is the Chargy Bank, to a third party due to the failure of the vendor to service the loan taken for the property. Adila, I think next slides, please. The plaintiff main concern here is first the losses that they had suffered for the deposit amount paid, and also damages when the property was sold to a third party. The cause of action here is the defendants had breached their duty of care as an advocate and solicitor to act with a reasonable care, skill and due diligence to ensure that the property was free from any charge or encumbrances. Thus, plaintiff sued defendants on the ground of professional negligence. That's all from me.
Okay, next we are moving on to the issues. There are three issues to be discussed in this case. First, whether the defendant not acting with reasonable care, skill and diligence in performing their duties. Secondly, whether the defendants had breached their duty of care as solicitors in the matter of their action in the said SPA. And third, whether the plaintiff had suffered any losses or damages as a result of the defendant's breach of duty of care. Okay, next. In answering the issues, it was held that the defendant owed the plaintiff a contractual duty since there existed a solicitor-client relationship as the firm had been retained by the plaintiff for the transaction involving the SPA of the property. However, in this case, the defendant had failed to perform their obligation due to the standard of diligence and also liable in tort for their wrongful act of depriving the plaintiff from the benefit of the SPA transaction. Okay, next, the actions of the third defendant showed that she had negligently misrepresented to the plaintiff that the property was free from encumbrances. Okay, the third defendant failed to rectify the SPA to reflect the true circumstances. The unamended SPA was stamped and forwarded to the plaintiff. The court held that the third defendant should inform CIMB of the plaintiff's interest to buy the property and to try to negotiate to redeem the said property for the plaintiff. The failure to do so was a simple negligence as she failed to take reasonable precaution against reasonable probabilities. Okay. The main cause that the property was auctioned off by CIMB was due to the failure of the defendants to exercise due negligence, reasonable care and skill. The property was auctioned off as the defendants failed in not ensuring that the property was not subject to a charge. The plaintiff then were entitled to claim the deposit sum with interest and cost as the defendants not acting with reasonable care, skill and diligence in the performance of their duties. Okay, next we are moving on to comments and analysis.
For the comments and analysis, we found that the relationship between an advocate and solicitor with his client is one of a fiduciary relationship. Therefore, in a fiduciary relationship, the client places his confidence, reliance, and trust to the advocate and solicitor whose advice is sought in some matter. Here, in this case, Madam Wang and Mr. Lee established a fiduciary duty with the first and second defendant who were advocate and solicitor and partners of Mrs. David Koch and partners, and also with the third defendant who was a legal assistant at the firm. Section 84 of the Legal Profession Act indirectly highlight that a lawyer holds his responsibility and duty over his client. The purpose of Section 84 of LPA is to ensure that the purchaser is entitled to have the advice of an advocate and solicitor of his choice. The court in this case made a bold decision when it found that the first and second defendant from Mrs. David Koch, who were the qualified conveyancer, failed to fulfill their duty to run land title search to check for any encumbrance and charge on behalf of their client. Moreover, the third defendant inserted the wrong fact in SPA as there was a mistake made to recital 2 of the SPA in which the defendant represented to the plaintiff that the said property was free from encumbrance when in fact the property was charged to CIMB. This negligence led the plaintiff to believe that the property was free from encumbrance.
Next, the but-for test. showed that the cause that contributed to the plaintiff loss was the act or inactions of the defendant in not ensuring that the property was not subject to a charge. The defendant's action of not reflecting the true circumstances and forwarded the unamended SPA to the plaintiff is a grave mistake, which is unacceptable for the client who placed his trust in his solicitor. Thus, the defendant had negligently misrepresented and breached the duty of care as solicitor for not rectifying the mistakes but proceeded to execute the SPA by inserting the wrong facts to the plaintiff. The defendant should be liable to disciplinary proceedings as a consequence for exercising lackadaisical attitude, which the defendant failed to take an action to lodge a private caveat on the property to protect the plaintiff interest. In the case of Wu Xiu Ying and Gunung Tunggal Quarry and Construction Sembilan Berhad, it was held that a material contribution must be a question of degree. In this present case, the loss of the plaintiff's deposit sum was materially contributed by the defendant. The defendant, in fact, did not exercise due diligence, reasonable care, and skill even before the property was auctioned off. The defendant had failed to communicate with CIMB Bank to try to salvage or redeem the said property for the plaintiff. The plaintiff had indeed proved causation and loss, which then entitled the plaintiff to claim the deposit sum with interest and cost. In conclusion, there is contractual duty established in this present case between the plaintiff and the defendant. The relationship of a solicitor and client gives rise to a duty by the solicitor to exercise due care and skill in carrying out what he has undertaken to do for his client. The failure of the defendant to act as such materially contributed to the plaintiff's loss, hence the legal suit being initiated against the defendant. That's all from us. Thank you.
Okay, thank you very much, Group 2, for the presentation of Wan Xiao and another and Kok Wen Tak and others. Actually, based on the cases that we have discussed today, what are the important elements to prove in a negligence suit actually?
The relationship between the solicitor and the client.
Okay, that is one. The relationship, or there is a duty of care between the client and the lawyers. Okay, what are the elements?
Breach of duty of care.
Yeah, the breach of duty of care.
And lastly, the damages suffered by the plaintiff as caused by the defendant.
Yeah, the damage suffered by the plaintiff is caused by the defendant. I believe all of you have learned this in your talks, in second year or third year with regards to the suits of negligence. So we can see today that all the cases are the basis of the claim is on the basis of negligence by the professional person, meaning by the lawyers in carry out their duties. Okay. So we have the last presentation from the third group on Kok Wen Tak and Mbang Berhad. So can we please have the third presentation? Which group will be presenting?
Syafiqah Madam, sekejap ya, saya share screen.
Okay.
Okay, Madam, can I start?
Yeah, please.
Assalamualaikum warahmatullahi wabarakatuh. We are from Syafiqah and Associates. We will discuss on the topic on the case of Kok Weng Tak and others, and AM Bank. So I will go briefly for the introduction. Okay, first slide, the second slide. Okay, as for the introduction, this case basically discuss on a negligence of the solicitors toward the clients, especially in conveyancing matter, and it is to be noted that the negligence in conveyancing matter is one of the biggest causes of solicitors' negligence claim, and basically the solicitor or the conveyancing lawyer owed a duty of care when representing his client, and he must also conduct it the conveyancing matter with an appropriate level of professional skills. And these are some of the solicitor's responsibilities and duties that are they supposed to make inquiries and searches about the property or the land, checking the extent of the property to be transferred, and check whether any third party has any rights over the property or the land, and also any restrictions on the use of the property. The firm or the solicitor may be liable for the tort of negligence if the three basic requirements is fulfilled. Firstly, is the duty of care, where the solicitor owed the client a duty not to give harm to the client, and secondly is breach of duty, where the solicitor failed to act act in a proper manner, or the way that they should act, and thirdly is by the causations, where the client must prove that as a result of the solicitor breach of their duty, the client had suffered the loss. Next, we will move to the facts of the case.
Alright, in this case, it was started when the bank, which is the plaintiff, appointed the law firm, which is the defendant, to act on behalf of them in the security document for a loan to be granted to the purchaser in the purchase of 3-story shop. And then the property, even the property did not have IDP at that time. And then if any sale of the property would be necessary for by way of assignment from the developer. However, the plaintiff then received the defendant's letter of advice, which contained that the confirmation that the fourth defendant was the beneficial owner of the property, who had said that sold the property to the purchaser. Then the defendant gave the plaintiff a guarantee in the letter of advice, which is if the plaintiff suffered any loss as a result of it having acted on the verifications obtained by the firm, the plaintiff would be fully indemnified by them. And with that verification and guarantee, the plaintiff then released the loan. And then later after that, the plaintiff received a letter from the defendant stating that the developer did not recognize the fourth defendant, which is the vendor, as the assigner of the property. Thus, the plaintiff filed a suit against the defendant upon the acts of the defendants in issuing the letter of advice to release the loan. And with that of the letter of advice, the plaintiff subsequently acted upon it and suffered a detriment where it has suffered loss as a result of thereof. Thus, and then this case was an appeal made by the defendants, but the plaintiffs had filed a cross appeal because they did not agree with the findings of High Court judge of 30% of contributory negligence. The plaintiff stated that the law firm had breached the term of the engagement and fiduciary duty to the plaintiff, which act negligently pertaining to the legal documentation for the loan facilities. And then we moving on to the issues in this case. There are two issues, which is the first one, whether the High Court judge was correct when he found out that the law firm committed negligence or breach of contract, and second, whether High Court of judge was correct when he found, as a matter of fact or law, that the plaintiff was negligently contributing negligence on the 30%. That's all. Moving on.
I will proceed on the judgment of this case. In the High Court, the High Court judge ruled that the bank is contributory negligent to the losses suffered by them. But in the Court of Appeal, the appeal by the law firm was dismissed and the bank was allowed to do the cross appeal. In giving the decision, the Court of Appeal decided that the learned trial judge in the High Court was erred in finding that the plaintiff, which is the bank, is contributory negligent to the breach of duty done by the law firm, which has contributed to the losses suffered by the bank. The High Court judge applied the but-for test mistakenly, which had made the plaintiff is 30% liable for the damages, and the appeal court ruled in favor of the bank and decided that the law firm was 100% liable for the losses suffered. Therefore, the law firm was ordered to pay costs of RM 30,000 to the bank and deposit to be refunded to the law firm, being the appellant in this matter. Moving on to the principles, there are several principles used by the Court of Appeal in deciding for the case. Firstly, the Court of Appeal relied to Section 24 of the Contracts Act 1950, in which, in this section, the Contracts Act provides for considerations and objects which are lawful and unlawful. It is provided in this provision that the consideration or object of an agreement is unlawful if, firstly, it is forbidden by the law; secondly, it is of such nature it would defeat any law; thirdly, if it is fraudulent; fourthly, it involves or implies injury to the person or property of another; and lastly, it satisfies the court that it is immoral or opposed to public policy. Secondly, the court also relied to the principle of contributory negligence. Contributory negligence is negligence conducted by the injured party that is a contributing cause of his injuries, and which conduct falls below the legal standard for protecting oneself from an unreasonable risk of harm. The previous decision decided by the High Court ruled that the law firm was 70% liable and the plaintiff, which is the bank, was also 30% liable. This is on the fact that the plaintiff, by approving the loan application submitted by the purchaser, which is Lok Yopa, the court ruled that the burden of proof lies on the plaintiff to prove that they are not contributory negligent which caused their own injury. The court had to look for the causative factor. Causative factor means that who contribute to the losses, in which in this case, the law firm, which is the defendant, contribute to the losses. That is why the Court of Appeal put the 100% liability on the defendant. Thirdly, the court used the but-for test to determine the causation of a contributory negligence. Summarily, the but-for test is up on the law firm, which has the duty to do the necessary checks which had been mandated by the bank to the law firm, which is not being done by the law firm. Next, the court also relied on several cases, which is firstly is the case of LIFO and Sons Sdn Bhd and Screen, where the judge in this case ruled that if solicitors can be absolved of all of their liabilities if they insisted that they cannot foresee that a third party will commit fraud as a result of their negligence, then the retainer would be of no useful purpose. Secondly is the case of Anthony Ting Chua Pang and Wong Bing Sang, where it was held that the solicitors were negligent in failing to properly ascertain the true identity of the person who claimed to be the owner of the land and held the said solicitors to be negligent. The last case is the case of Yong and Co and We Hood Tech Development Corporation, where it was held that the liability of a solicitor may be viewed in two aspects, which is firstly, the retainer imposed upon him an obligation to be skillful and careful, and for failure to fulfill his obligation, he may be made liable for negligence. That is all for judgment and principles.
Okay, moving on to the analysis and commentary. In this case, our firm agreed with the decision of the High Court in dismissing the appeal of the appellant law firm. We agree that the High Court was correct in finding that the law firm committed negligence or breach of fiduciary duty. However, the High Court missed a point in finding that the plaintiff was 30% contributory negligent. This is because although it seems as the duty of conveyancing lawyer is quite simple, that some lawyers just delegate their duties to their conveyancing clerks. Lawyers should still attend to the legal documentation without having proper monitoring system in place. This is because if the lawyer would just delegate their duties to other people, then the purchaser or the developer would be better off without contracting the law firm in the first place. To recap, in this case, Christopher, which is the solicitor in the law firm, had employed a freelance dispatch clerk which was introduced to him by the fourth defendant in order to do the liaising with the developer. This means that not only the freelance dispatch clerk is not an employee at the law firm, he is a foreign person. Yeah. To make matters worse, Christopher did not make any record pertaining to this freelance dispatch clerk. Therefore, there was no way of tracing this dispatch clerk. Christopher also did not follow up to ensure that the developer received the documents handled by the freelance dispatch clerk. Albeit the findings of the High Court, there is still some points missed in finding that the respondent was 30% contributory negligent. This is because it is a duty of a solicitor to ensure that all the documents must be properly prepared to carry out a thorough inquiry and to ensure that the details stated in the transactions documents are correct. In court also have to scrutinize all the processes and steps taken by the conveyancing lawyer from the first stage until the final stage when the relevant agreement is signed and stamped by the contracting parties. Hence, we agreed with the Court of Appeal in finding that the law firm never liaised with the developer directly. In this case, if due care and attention had been exercised by the solicitor, it would have been discovered that the property was never purchased by the fourth defendant. For me, we will move on to the conclusion.
So in conclusion, from this case, it is crucial to scrutinize that the process as fraud and forgeries in land transactions are quite common in Malaysia. Hence, why the public entrust the conveyancing matters to the solicitors. In the event that if there is any loss suffered by the parties because of the negligence on part of the lawyers, the state lawyer may be held liable for the breach of fiduciary duty and also liable for the professional negligence. It is worthy to note that the relationship between an advocate and solicitor with his client is a fiduciary relationship. So in conveyancing matter, as in the above case, it is a duty of a solicitor to make sure that all the documents pertaining to the transactions of the land must be properly conducted, prepared to carry out a thorough inquiry and to ensure that all the details that are stated in the transaction documents is correct. So that's all from us.
Thank you, Afifa and the third group for the presentation of what is the name of the cases now? Kok Wen Tak and others and M. Bam Berhad. So I believe from the sixth presentation just now, you have learned a lot. What are the duties of the solicitors in handling conveyancing matters? So what are if we look at the three cases, what are the qualities of a good conveyancer? What are the characteristic of a good conveyancer or conveyancing lawyer? Anyone would like to try?
As for me, for my opinion, I believe that to be a good conveyancing solicitor, it must be a person who have a full knowledge regarding what he will be doing in that matter, meaning that before he start taking any client into his interest, he must show that he has full information to assist his client. Okay.
Okay. So he must be a knowledgeable person about what he's going to do. Yeah.
Yes.
Right?
Yes,
Okay.
ma'am.
Okay. Others? One is a knowledgeable.
Madam, in my opinion, a good conveyancing lawyer should have an eye for the details, which means that the lawyer should scrutinize all the documents and siasat background parties involved, all that things, and not skip any part of it.
Okay.
That's what I
True.
think.
Yeah, very true. The eyes of the details, or he must be very meticulous person with regards to his work. Meaning he can spot automatically what are the mistakes in the documents and so on. Okay, what else? What are the traits or the characteristics or the qualities?
Madam,
Yeah, Khadija?
for me, to be a lawyer in general or conveyancing lawyer in particular, he must be an ethical person, which is in the last case that had been decided by our had been discussed by our firm, the case of Kok Wen Tak. It can be said that it is the basic practice of the lawyer to record all of the documentation of the clerk. But it had not been done in that case, which we can be said as a human. It can be said that the law firm may have engaged with the clerk to do a fraud. So for me, the lawyer himself, whether he is a general lawyer, a conveyancing lawyer, he must be an ethical person so that he will not engage in something that will brought him to the disciplinary proceedings.
Yeah, true, very true, Siti. On the must be, a lawyer must be a very ethical person because they are the one who uphold the law, so they must follow strictly, and they must the person who actually follow strictly what is ethical and what is unethical. He must know it very well. Sometimes it's very sometimes there are also lawyers who actually colluded with these fraudsters to do something against their client. So it's happened in reality. Okay. Anyone else would like to add to the what are the qualities, good qualities, what are the qualities needed to be a good convincing lawyer or lawyer in general? Ada lagi yang nak tambah?
Madam,
Hmm.
I quote what have been said by the Siti Khadijah before. I think it was prudent for the solicitor to act honest and taking all the responsibility if he's own that responsibility. If any dispute arises between him and his client, he must the one who's clarify everything, not run away from the issues.
Yeah, true. He must be responsible for whatever happened towards the file, so he cannot run away or hide behind his clerk or something else or push the blame to others. So if that mistake or negligence is committed by him, he has to admit it and try as much as possible to rectify it if still have chance to do it. Yeah. So I hope all of you have learned something from the three cases that we have discussed today. So as I think all of you aware that in a legal firm, every lawyer are insured by a professional indemnity insurance. The legal firm is obliged to take an insurance for each of their lawyers to cover if there is any mistake or negligence happen during their work. And this insurance has to be renewed or taken every year. So every year, the legal firm must take an insurance for their lawyers. The higher the value of the legal firm handling handling their work, the more the insurance coverage that they need to take. So if like in this case just now, in Mofa Keluang, the firm have to pay 3 million ringgit, 3 million plus to the client because of the negligence. So the insurance will cover if they have enough insurance for that amount. If not, then whatever balance which is insufficient will be actually topped up by the firm by the legal assistant herself or himself. Okay. So I think that's all for today. Any question before we end our session today?
Madam, boleh tak nak tahu tarikh exam conveyancing? Tarikh exam
Tarikh
conveyancing.
Dah keluar, rasanya belum keluar kan? Exam date. Dah keluar ke?
Tadi siapa? Dr. Fajri ada bagi screenshot. Tapi
dah
tak
ada
ada
untuk
conveyancing. Yang lain dah ada.
Oh, okey. Ya, okey. Saya check, saya tak perasan. Tapi nanti saya check dan inform dalam group kalau if the information has actually been given to the lecturers lah. Untuk subjek lain dah ada ya, Adila?
Dah ada.
Semua ada kecuali convey.
Betul.
Oh, maybe they miss it out. Okay, so nanti saya akan maklumkan. So thank you very much to TLB 7 and TLB 8. So insyaAllah next week we will meet again for the quiz session. So kalau untuk quiz next week mungkin sebab soalan dia akan jadi sama kan. Jadi mungkin TLB 7 masuk satu group yang berbeza lah. You jangan masuk combine. Ya? Boleh?
Boleh, nanti saya cuba aturkan masa.
Cubakan aturkan masa sebab dalam tutorial group tu memang dah ada TLB 7, TLB 8 yang dekat MS Team tu. So cuma kalau masa tu nak ubah ke apa, just let me know. Tapi maksudnya yang orang TLB 7 saja yang akan masuk during the session lah. Sebab because kita ada quiz dan soalan tu sama. Jadi otak macam TLB 8 pun dah tahulah apa soalan yang akan ditanya kan. Okay, so nanti Faiz tolong arrangekan macam mana masa dan sebagainya.
Sure.
So thank you very much. Assalamualaikum warahmatullahi taala wabarakatuh.
Wassalamualaikum warahmatullahi wabarakatuh. Madam, by the way, untuk Madam, untuk quiz apa yang kami topik apa yang kami patut prepare?
Dia cover semua daripada awal sampai akhir. So soalan
Baik.
dia very simple question, basic question saja. So don't worry too much. Dia adalah general knowledge and I believe all of you akan tahulah insyaAllah. Ya.
InsyaAllah. Thank you Madam. Assalamualaikum.
Salam.
Leaf daun.
Muiz, remove aku Muiz.